Probably not.
Okay.
What would be in your system?
I've been tested dirty for cocaine and THC, I believe.
3 successive occasions. Mr. Allen. Bond violation report.
But I haven't even been out a week to get my...
Hold up, competency hearing time. This isn't about guilty or not guilty. It's about whether the defendant's mind is clear enough to even stand trial. Do they get what's happening? If the answer's no, the whole case freezes before it even begins.
I'm clean. I just caught this charge and the bond was just set, so I haven't had time to actually get my system clean.
I have a whole week of testing with cocaine in your system.
We also have a failure to appear for CCOP, is that correct?
For CCOP, what's that?
It's the
That's
community
true.
correction stuff.
No, oh yes, they rescheduled my appointment for Monday at 9:30 with the brown guy for the outpatient program.
Yeah.
Yes, 'cause I thought I showed up at 2, it was at 1:30, and then I also dropped yesterday.
Why is cocaine still in your system?
It will not be today.
Well, you just told me it was going to come back.
Because I haven't dropped clean yet, that's why I assumed that. I don't know how long it takes to leave
You're
my system.
still using.
No, I'm not.
No, because you want. Okay, I'm going to tell you what. You're telling me you're not. I'm going to take you back. I'll call over, get levels, and then we'll see exactly what's happening.
So I got
You want me to do that?
so I can drop today?
No.
I'm sorry, I
You
didn't.
would go back there with my bailiff. I will call over and get levels. If you're telling me that your system is just cleaning out.
My system should be clean.
No, that's not what I'm saying. You're telling me you're not using,
Correct.
right?
Yes.
Okay. Then this must be some super duper cocaine.
I have.
So we'll figure it out. And so what I'm gonna do is, Mr. Allen, you can take him back. We will call over to community corrections, get your levels, and then we'll figure out what's happening. Court does call the case People versus Romeo Serba. Oh, 2 in a row.
Kelman Adish on behalf of Mr. Serval, who is approaching.
Your name, sir?
Romeo Serval.
Thank you.
The judge drops the $1 million question, will you test clean today? The reply isn't just a no, it's a hard no. Cocaine and THC still show up, and the defendant hasn't even been out long enough to sober up. Things are about to spiral fast.
Your Honor, we are going to be asking for an adjournment for mitigation, and we would like to address bond, please.
Probable cause conference will be adjourned May 29, 2025, 9 a.m. I need a green sheet and then next bond.
As to bond, Your Honor, I wanted to address, I wanted to ask for him to be released on tether. Your Honor, Mr. Servo is 20 years old. He has 2 children that he takes sole custody of. He has to take care of them right now. They're in the care of his father and his foster grandfather and foster grandmother, who aren't able to actually keep taking care of his children. He has been in school. He has a 4.0 GPA. He just got his transcript back. He had a job interview. He's doing really well. The reason he was missing them is just because he had so many things going on. They were early in the morning. He has these 2 kids. I can assure you that if you put him on a tether, Your Honor, that you will be seeing obviously no mistests, but no positives or anything like that. He is not drinking. He doesn't drink. He reacts very poorly to it. So we are going to be asking for that.
Yeah, but he wasn't.
Must be some kind of miracle cocaine. The judge fires back with biting sarcasm and, honestly, fair enough. When a defendant swears they're clean but the test screams otherwise, something's off. It's either chemistry, comedy, or a messy mix of both.
Testing on his SoberLink device. I mean, he just wasn't testing like he should.
Yeah, there's 2 that he missed. He was in custody for those. Those are the first 2 missed ones on the report from March. And then he had 4 missed ones, but he submitted a compliant test like within 15 minutes.
I'm talking about, I got that, but his April 24th report from Community Corrections.
I'm not in receipt of that. The last one I have is as of April 23rd. I may have missed it, but
April.
the report that I have.
Next case, fresh drama. Romeo Serbo steps in. This one's about mitigation and bond. He's only 20, raising 2 kids, rocking a 4.0 GPA, and lining up job interviews. Feels like the start of a redemption story, but the courtroom doesn't hand out gold stars that easily.
The last test on there that was missed was the 23rd of April. Let me look.
Right, but do you have, there should be a bond violation report from April 20, that's dated April 24th, 2025.
Oh, this is the one. Oh no, sorry. Yeah, April 24th. This is the same one I'm looking at.
Okay.
Okay.
Go ahead.
Yes. Again, as 2 of those were missed when he was in custody elsewhere. 4 of those he missed, but he retested like within 20 minutes, 15 minutes, 7 minutes after the 9 a.m. block. I believe there's only 2 that he missed that he never retested for, and those were the newly added time window. I believe he had either forgotten about those, and I understand that that's not an excuse. He just has a lot going on with school, with work, with his 2 kids, and that's why I believe having him on a tether would resolve this issue. He should have been put on tether from the beginning, honestly. But if Your Honor releases him on that tether, and he's not missing any of his drug tests. So,
Any response? Anything?
The only thing I'm concerned about was in September of 2023, the defendant was placed on probation. The Oakland County Circuit Court on 2 counts of RIO and then B&B or HIDA. And obviously this offense occurred in June of 2024. So it would have been while he was on court supervision, Oakland County Circuit Court on a similar charge that also falls regarding the defendant's ability to cover.
Your Honor, he is undergoing mitigation for mental health concerns that we're going to provide to prosecution. I've talked to his attorney in his Oakland County cases.
Missing tests is one thing, but missing them while on probation across multiple counties, that's a logistical headache. The defense claims he's overwhelmed. The prosecution raises an eyebrow. Who's buying it? You be the judge.
He is on probation for those. He's testing in so many different places for so many different things. That's why also he is having trouble keeping track of these tests. And I mean, again, I believe a tether would help with all, huh? What do you want?
I just wanted that I did have. When I realized it was going to be a problem, released him, so I won't have any problems with it.
Yeah. He's saying that he requested, well, he wanted a tether in the first place, and
When you're saying a tether, you're talking a scram tether?
Yes, sir. And if I was to get that, I wouldn't have any problems. You wouldn't hear it from me. I don't drink alcohol. There's no alcohol in my household. It's just 2 children, and I go to school every day.
2 children and some pot, right?
Well, I smoke outside the house, and it's never around them.
Okay. Do you have a card?
Yeah, I do. And
Did you give us your card?
I offered to give that to community corrections, but they refused to take it every time I offered it to them.
and his father submitted it. They'd already submitted it to community corrections. I don't know why community corrections lost track of it, but I talked to his father yesterday, and his father said that he sent community corrections a copy of it again yesterday, but that every time he goes to test, he has his medical marijuana card on him and it's active. And I can send that to the court right now.
I will modify his bond, although he may not be entitled to a $25,000 personal recognizance bond, but he needs to be on a scram tether prior to release.
Thank you, Your Honor.
And I've set this over to the 29th.
Thank you, Your Honor.
Thank you.
Thank you.
Court does recall the case, People versus Hill.
I think there were two different for the people.
Well,
Yes, Your Honor, we did receive the results in this matter, and I have discussed them with my client. And what the likely outcome will be based on that result.
Pardon?
And what the likely outcome will be based on that result.
Well, just so the record's clear, he had indicated to me that he hadn't taken it, hadn't been using, but levels started out in May of cocaine, started out on May 7th at 424, then went down by May 9th to 353, but then by the 14th shot up to 889. So anything else you want to say? He's been using.
Your Honor, my client is just asking for a 1-week adjournment in this case. We're gonna have him screened for drug court to see if that's a suitable, a good fit
Probable
for him.
cause conference will be adjourned May 29th, in 2 weeks.
2 weeks. Thank you, Your Honor.
Absolutely. 2025, 9 a.m. His bond is revoked.
And Mr. Hill?
People versus Sherry Hughes.
Gabriel, deputy for the people.
Morning, Your Honor, Mike Gandy, Assistant Public Defender on behalf of Ms. Hughes, who's not here. Judge, I did submit a green form. I did receive a call from Ms. Hughes' mom yesterday stating that she was at St. Joe's psych ER. I got a call around 8:30 saying that they're waiting to be discharged. And I don't think she's in a position to actually be still going to court today. I'd ask the court to excuse her presence and adjourn this matter.
Well, I'll need some documentation, but Mr. Getty, but I'll adjourn this over to the 22nd, 1 week out.
Thank you, Judge. I will.
2025, 9 a.m.
Thank you. I will provide the discharge paperwork when I get it. Thank you.
Court calls the case of the people versus, is it it's LaDonta Skinner. I don't know why they have it this one.
Gabriel, deputy for the people.
We're ready in this matter, Your Honor. Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Skinner, who approaches the podium. Skinner, please state your name for the record.
LaDonta Skinner.
Thank you. Your Honor, today is the date and time set for the probable cause conference. We are respectfully requesting this matter be set for preliminary examination.
Both matters.
Yes, please.
Discovery is complete.
Yes, to the best of our knowledge, discovery is complete.
People have their witnesses available the 27th. Preliminary examination, May 27th, 2025, 9 a.m. That will be before judge. Continue.
Okay, Your Honor, what does the court show as the bonds in these matters?
1,000 cash surety on the case ending in 5724. And on the other matter, same thing. 10%?
Both are 10%, Your Honor?
Hmm?
Both are 10% allowed?
It is cash surety 10%.
Okay, all right. Thank you very much, Your Honor.
Court calls the case people versus Joel Stevens.
On behalf of Mr. Joel Stevens, who is approaching.
Joel Stevens.
All right.
Your Honor, we are going to be setting this for a preliminary examination, please.
Discovery is complete.
Yes, Your Honor.
People have their witnesses available the 27th. Preliminary examination, May 27th, 2025, 9 a.m. That's before Judge Washington. Bond will continue.
Thank you, Your Honor.
Court does call the case people versus Davian Thomas.
We're ready in that matter, Your Honor.
Andrew Children, appearing on behalf of the people.
Lauren Brown, Deputy Chief Public Defender, they're appearing with and on behalf of Mr. Davion Thomas. Mr. Thomas, could you state your name for the record?
Davion Thomas.
We're doing the plea.
Yes, please.
The plea form indicates a defendant will be pleading guilty to an added count 3 of larceny by false pretenses, 200 to 1,000 to 1 year offense. On his successful plea to that charge, counts 1 and 2 would be dismissed, and it is okay for him to seek hideout in the case. That's the agreement.